Good afternoon. Thank you for joining us on this Thursday afternoon. Here in London, the clock has just struck at St. Paul's Cathedral, which tells me that we're at least starting on time. I appreciate you taking time out of your day, and we're here today to talk about how to protect against bribery and corruption in infrastructure projects. My name is Judy Krieg, and I'm a partner in the London office of Shepherd and Wedderburn. I want to remind you all that if you have any questions, please feel free to ask them. You have a chat facility on the interface, and by all means feel free to use it. Also feel free to follow up with me if you have any questions, but we will leave some time at the end if you do have any questions. This is number 4 in the Procurement Reform webinar series of Shepherd and Wedderburn, and this is a brief description of what the first 3 webinars look like. This is actually the last in the series. So if you are interested in listening to any of those, you can log on to our Vimeo channel, and we are recording this, so if you do need to leave us early or want a replay, then you can also have that available there. This is just a brief description of who I am, also available on our website, and in case you're curious, that's what I look like. So I'm going to briefly show you what we're going to be talking about today. We've got 4 different areas I want to talk about and then leave room for questions in the end. Basically, I do want to try to focus, though, on the second to last area, the practical tips for how to protect yourself. Before we get there, we will briefly canter through why are infrastructure projects such a high risk for bribery and corruption, what types of bribery issues can arise in infrastructure projects, and I'm going to talk very briefly about the enforcement arena in which we're living. There's been a shift in how bribery issues are being enforced in infrastructure projects and what I'm calling the new normal. So very briefly, why are infrastructure projects such a high risk? And I just want to note the fact that we have people listening in from all sorts of different aspects of infrastructure projects. And I think that speaks to one of the reasons why they can be such high risks. Infrastructure projects involve a lot of money, a lot of different players, and a lot of buying or procurement decisions as to where that money goes. When you combine that with typically some government involvement to sometimes a lot of government involvement, you end up with a situation where there's just a lot of money flowing around, and as John Dillinger said, he robs banks because that's where the money is. And these projects are at high risk for bribery and corruption because that's also where the money is. There's a whole host of different bribery issues that can arise in infrastructure projects, and again, some of these will be more relevant to some of you than others. But briefly, I wanted to talk about the really broad range, overwhelming range of bribery issues that can arise in infrastructure projects. Starting with the top of this circle, sort of the 12 o'clock position, project finance. Who's going to actually be lending the money or getting the money to be able to finance these projects? And this can be quite a bit of money involved. You have bribery issues that can arise with the people that are involved in those decisions. Moving around the circle clockwise, the award of the contracts. Again, some very significant decisions that need to be made, and how are people influencing those decision makers? Who's going to actually be building these projects? Moving down the circle, you've got the whole host of subcontractors and consultants in the value chain. And again, this is just another example of where you have procurement and spending decisions being made, and people that are actually spending that money in different ways. Supply chain. There's lots of buying that goes on in infrastructure projects and lots of goods moving around. Again, bribery risks in both areas. Permits and visas. There's typically in infrastructure projects, you need permissions to do what you need to do, and you need permissions for people to be in certain locations in order to do it. You get situations where you can have grease payments or facilitating payments, which is just to facilitate some of these permissions, or you can just have flat-out bribes, where people aren't really entitled to do what they're doing, or just skip the mechanisms altogether and just get their permits and visas by bribing people. Moving up the circle further, we've got a lot of government interaction. That can rise in all sorts of different ways, from ownership of the project to project approval, to budget allocation, and lots of opportunity for what we call PEPs, or politically exposed persons, to be involved in the myriad of issues and decisions that need to be made in infrastructure projects. And then finally, we've got local partners and joint ventures. These are the different types of people that you need to partner up with in order to get these projects done. Depending on what country you're in, some people listening in deal with international issues, some are more UK focused. But depending on what country you're in, with infrastructure projects, you may be legally required to partner up with a local company or even a majority-owned local company. You may also have local content or local participation requirements in connection with your infrastructure project. So a whole list and a whole host of ways that bribery issues can arise in infrastructure projects. Now, as I'm sure all of you know, there's no shortage of enforcement issues that have arisen in the infrastructure area. And I want to talk a little bit about what I'm talking about, old-style infrastructure bribery issues. These are just a short list of some of the infrastructure companies that may be familiar to some of you. And I apologize in advance if anyone on the phone is affiliated with any of these companies. I know it can be uncomfortable when you have that involvement to see your company's name splashed up there in a presentation. So I'm not making any value judgments, just pointing out facts. We've got everything from PBS&J International and Lewis Berger and KBR Halliburton that are more typical U.S. FCPA resolutions, deferred prosecution agreements, and in some cases individuals going to prison that were related to those companies. One of the reasons why I've mentioned some of these names is they do have a UK connection. PBS&J International was acquired by a UK PLC, and therefore, even though it was a U.S. enforcement action, can show how, in the M&A context, some of these issues can affect UK corporates. The Edinburgh Action Building contracts is a recent situation where 4 individuals were jailed. City officials were awarding contracts to Edinburgh Action Building contracts for infrastructure maintenance. That involves kickbacks and some good old-fashioned gifts and hospitality issues. Standard Bank I've put on here as an infrastructure issue, and it's not something that people typically think of as an infrastructure bribery issue. But Standard Bank, as many of you probably know, was the first deferred prosecution agreement under the UK Bribery Act, but it had to do with a bribe in order to be able to arrange financing for an infrastructure project in Tanzania. The bank's sort of sister-stroke parent company was here in the UK and ended up with the UK deferred prosecution agreement for an infrastructure project-related issue in Tanzania. And then finally, I don't want to lose sight of individual prosecutions that have taken place up until now for bribery issues in infrastructure projects. Even as recently as this week, just a few days ago, an individual in the U.S. pleaded guilty to bribing an official from the EBRD, the European Bank of Reconstruction and Development, here in London. So it just goes to show that you can have individuals involved, and in that situation, there are 2 individuals in the UK who've also been charged with bribery offenses, and they're currently awaiting trial. But the point that I'd like to make as being either FCPA or UK Bribery Act related, and nothing more than that, are somewhat over. And the landscape for enforcement of bribery issues and infrastructure projects is getting more complicated. So I want to talk about what I'm calling the new normal. If you've bothered to pick up a newspaper or have had any exposure to the media, even in the last few weeks, I'm sure you've heard about the Panama Papers. And there are actually a number of journalist exposés that are publicizing what I'm calling large-scale bribery scandals in a way that up until now, up until a few years ago, was really unheard of. And I want to give you a few examples of some of these exposés that are either currently affecting the infrastructure, bribery and infrastructure, or I think have a real significant likelihood of getting there. First one I want to talk about very briefly is 1MDB. 1MDB is a fund that the Malaysian government set up to fund infrastructure projects. It was an expose that was put online by something called the Sarawak Report and the Sunday Times in London, where the Malaysian Prime Minister received a $680 million gift. Yes, you heard that right, gift, from Saudi government officials. That has basically exploded into a whole host of investigations. And because it all relates back to infrastructure projects in the Malaysian government, it I think has a likelihood, if not certainty, of reaching into all the different players that were involved in those contracts. Currently, the focus is on the Malaysian Prime Minister who received some of these monies. It's being focused on the banks that laundered the monies. But I think it's just a matter of time before they also start looking at the companies who were involved in the contracts where the monies came from. To give you some example of the scope of this, the Swiss authorities are estimating that $4 billion, yes, that's billion with a B, have gone missing in terms of Malaysian state-owned companies. Unioil is a expose that was just, I think, about 2 weeks old now. Fairfax Media, which is based in Australia, and the Huffington Post exposed this one, based on a leak of documents relating to a Monaco-based company that was a third-party intermediary for a number of oil and gas companies in infrastructure projects in the Middle East, Africa, and Asia. This expose involved several days of a series of articles, but it does name some U.S. companies and even names a few Scottish companies that were involved in supplying and building some of these infrastructure projects. I mentioned the Panama Papers briefly. It's obviously a consortium of journalists that have now been in the news almost consistently since the story hit papers of laundering money, and obviously it's going to lead back at some point to bribery issues in a whole host of countries. And then the Sweet Group, which again, if you follow the corruption world, was a recent guilty plea under the UK Bribery Act. And it's a company that dealt with some services for infrastructure projects, in this instance in the UAE. What I wanted to mention about this, though, is that one of the ways that the Sweet Group issue came to be disclosed to the UK Serious Fraud Office was that the Wall Street Journal was about to run an expose and a series of articles based on allegations and some documents that they'd obtained about bribes being paid. So really, again, this is all being driven by the media. What I think this means for companies that have to deal with concerns of bribery issues, or infrastructure companies, is that you're seeing these stories being told more and more, and often for the first time or the only time, in the media, in the press. What that means is that if somebody in your company has a concern or has an issue, don't be so sure that they're going to come to you first. Don't be so sure that they're going to go to the government first. The other effect that I just want to point out with what's happening with the journalist and the exposés leaking these stories, or rather telling these stories for the first time, is issues of attorney-client privilege and commercial confidentiality don't matter. If you think about the Panama Papers for a second, that was a leak of papers that were contained within a law firm. Actually, it wasn't a leak. It was a hacking of law firms' files. Those are documents that I think we would otherwise consider to be covered within the attorney-client privilege. But with this new normal of journalists exposing these things for the first time, you don't have the opportunity, if you're one of the companies that's being named or being implicated in this, you don't have the opportunity to raise attorney-client privilege or to think about how you're going to protect your commercially sensitive information. The other thing we're seeing with the new normal is that what can start with a focus on politicians trickles down into an inquiry on companies and infrastructure bribery in particular. Again, some of you have probably read about Operation Car Wash in Brazil, which started off with an investigation into currency exchange outlets in Brazil, led very quickly into an investigation of all of the major construction companies in Brazil, Petrobras, which is the Brazil state-owned oil and gas company, and politicians in Brazil, and most recently has led to the impeachment proceedings of the Brazilian president. UK companies who were involved in these infrastructure projects in Brazil have been named by whistleblowers in Brazil. So even though it started off as a Brazilian issue and is looking at politicians, it is trickling down to UK corporates in particular. The Rio Olympics in Brazil are now also under investigation, not surprisingly, not just in connection with the building of the facilities themselves, but also some of the support facilities in one of the ports nearby. I mentioned 1MDB in Malaysia, and that is also affecting the Prime Minister of Malaysia, but you will see that trickling down into the companies that were involved in the infrastructure projects in Malaysia. Nigeria. We've had a regime change in the last few years in Nigeria, and President Buhari has specifically said that corruption is one of his, or anti-corruption rather, is one of his priorities. It's politically helpful for the Nigerian government to point to the previous regime, and you're seeing cooperation out of the Nigerian government at a new level. Some estimates are that the amount that's gone missing, and that's a euphemism, polite euphemism for potential bribes, is about $20 billion with a B. And then one that I just wanted to mention briefly, the Kyrgyzstan Prime Minister recently resigned, and his whole cabinet, by the way, for allegedly rigging a $100 million road construction tender. So yet another example of how political and senior government official investigations can trickle down into looking into what's happening with companies. Also, very briefly, you're seeing more international cooperation across different countries, which means access to evidence that may be difficult to get. You're also seeing countries taking up cases where corrupt governments might turn a blind eye. And again, Malaysia, 1MDB is a really good example of that. The Malaysian Prime Minister had the Attorney General look into this $680 million gift, and the report came back that there was nothing of concern. The matter is now being investigated by Switzerland, the UK, the US, Singapore, and a few other countries as well. Finally, before we get to the heart of this, people are using laws other than anti-bribery laws to reach to bribery issues in infrastructure projects. The UK and the US in particular are using money laundering laws, they're using racketeering laws, and they're using fraud laws. So if you have a perception that you might not fall within the FCPA, and you might not have a US connection, or the Bribery Act might not be exactly on all fours with what your concern might be, I wouldn't consider that you're home and dry, because you are seeing governments getting very active in ways to combat this. So having said all of that, I want to get to the heart of what we're meant to be talking about today, how to protect yourself. And I'm going to give some practical examples of how you can do that. But before I do that, I want to just sort of state what should be quite obvious. Some of these suggestions and some of these protection mechanisms won't apply to everyone that's listening in. This is not a one-size-fits-all area, and bribery risks really are not. It is important that when you're considering how you or your company is going to respond to these risks, that you update your risk assessment, because this is a situation where you want the right horse for the right course. So, let's get to the practicalities here. First thing I want to talk about is third-party intermediaries. Even though I'm saying third-party intermediaries, it also applies to things like subcontractors, who owns them, your JV partners, your consultants, people that are providing services on your behalf that you're paying money to. It has traditionally been the way that companies get tripped up on bribery enforcement issues. And it's an oldie, but it's still a goodie. And even though the way these enforcement actions are coming about is changing, this is still a very key issue. In fact, the Unaoil scandal, it is all about the intermediary, because that's whose documents were leaked. I'm sure you all have excellent due diligence programs in place so that you can understand who it is you're doing business with. And that's good. In fact, it's viewed in many situations as a requirement, but it really only goes so far. So don't think just because you have a due diligence program in place that you're protected. What is really important and what will protect you more should you ever come under a bribery inquiry is, do you have a clear description of the services that you're meant to be receiving? What is the value for money proposition for bringing in that particular third party to conduct those particular tasks and have them be paid that particular amount? That clear description of services and that value for money needs to be very clearly documented, and it needs to be understood by the people in your compliance group and in your business that are approving either the subcontract award or the use of that JV partner or consultant or third-party intermediary. Within your company, it's very important that you set up very clear roles and responsibility for who's overseeing the performance of these third parties. What happens very often when the government comes in or law enforcement comes in and they're asking, what do these third parties do for the money? The business people involved will turn to compliance and they'll say, well, compliance approved this. And the compliance people will come in and say, well, we really didn't know what the third party was doing. If you want to make sure that you have the best defense possible or best response available if you ever come under law enforcement scrutiny, you want to know that somebody is overseeing what these third parties are actually doing. And I would suggest to you that that's something that typically would be someone in your business, not somebody in compliance. It's also very important that whatever contract you have with this third party is aligned with whatever you've done internally in your value case. All too often, when the business wants to use a third party or a consultant, they'll make it look like that they're going to perform a whole bunch of tasks to make it look like that's what the money's for. And they think that it's going to be easier for compliance to approve the use of that third party and pay those monies if they're doing 10 different things for you rather than 2. The problem is that if your contract says they're doing 10 things for the money and they don't actually do 10 things for the money, then you have to explain why you're paying money for something other than what they should be doing. So you need to make sure that whatever your business case is for the value for money is aligning with not just what you're overseeing, but also what's in your contracts. If there's one takeaway that you take away from this presentation today, it's this one: proof of services. I can guarantee you that if law enforcement or the authorities come in and ask you about what you're doing with a third-party intermediary, they'll want to see your due diligence, but what they're really going to want to see is proof of services. If you can show and you have evidence that your third party is doing what you thought they were going to be doing for you and what you thought you were paying them for, that is the best defense you can have for your company to respond to any sort of government inquiry or question mark about what that third party is doing. Proof of services is going to be more important than your due diligence report, I promise you. One of the other things that we're seeing in terms of bribery issues in some of these exposés that we're seeing from the journalists is inflated contract prices. That's where the bribes are being hidden. Even though traditionally people have looked at where the monies are flowing to the third parties, we're seeing in Petrobras and we're seeing in Unioil that what's happening is that the arrangements are made and the agreement is reached that the companies that are doing business in these projects will increase their prices by a factor of 10, 20, 30% or more. And then that extra money is the, for lack of a better term, slush fund. That's exactly what we're seeing with Petrobras in Brazil. That basically there was about a 30% markup on all the suppliers and all the people that were feeding into these infrastructure projects in Brazil, and then that 30% was being used to pay off senior officials in Petrobras and government officials. So when you're talking about how to prevent against this or protect against this, you want to make sure that your invoices aren't padded and that your overall bid amounts are not being padded either. I'm going to suggest to you, and I know this isn't going to be very popular among some business people, give compliance a role in the bid preparation or proposal process. If you have your compliance people involved in what you already have in the companies that are involved in this end of the value chain, they can see how those numbers are being put together, and what you find is that compliance people in your compliance group has a different perspective on things. Now, I know business groups really don't like it when you say, gee, I really want compliance people to have a seat at this table when we're setting up our proposal or we're deciding our best and final offer. I also promise you, however, that if you have ever been through the very painful process of having to retract a bid or having to decline to participate in a contract after an award because you've learned after the fact that the way that your bid was put together isn't entirely on the up and up, that is a significantly more painful process than having compliance sitting at the table at the outset. This really is a situation where an ounce of prevention is worth more than a pound of cure. And when you also consider the fact that the offering of a bribe is also an offense, having your compliance people involved in the early stages or before your bid goes out the door can really protect you much and detect these issues at a much earlier stage. We're also seeing in both in terms of some of the old style enforcement actions, but certainly in relation to some of these new exposés, confidential information and bid rigging is taking place in infrastructure projects. What does that mean by? What do I mean by that? Competitive intelligence is another way that you might call it within your company. What happens in these situations is that people are paid bribes or paid money that they shouldn't be paid in order to leak confidential bidding information. This can be either directly, in other words, one of your employees is receiving a kickback or somehow incentivized to be providing your confidential bid information, or it can be indirect, companies paying third parties, sometimes employees in the companies or within the government agencies, to provide to you, and I use you in the generic sense, information about what your competitors are bidding and actually telling you what those amounts are. When it's indirect by a third party, it could be either a direct kickback or you may see this disguised as quote-unquote consulting fees. You should be suspicious of competitor information or competitive bid information that is too detailed. When you get the exact number of the other bid, a precise amount that you're told that you need to sharpen your pencils by, you should protect yourself against this by making sure that whenever you have competitive intelligence or competitive information, that you're documenting the source of it. There is nothing wrong with obtaining competitive information legally, but it is such a red flag area from a bribery standpoint that if you are documenting where you're getting that information, if it's the internet, if it's a phone call, having that documentation that you've obtained it properly is definitely going to help you should you ever come under question. And once again, I'm going to suggest that putting compliance in a role where they are having some involvement in how you're getting competitive information and how you're documenting it is going to be helpful. Your compliance people will look at this information and how you get it through a lens slightly different than your business people who will feel like it's a real win to have information about what your competitors might be up to. Moving on, I want to talk about audit rights. And to be clear, I'm talking about the right to audit the books and records of your business partners, intermediaries, subcontractors, and third parties that are doing business with you. Rule number one, have them. Your contracts with these third parties should explicitly state what your audit rights are and how you exercise them, and I'm going to go through some hints on that. Rule number two, use them. There's no point in having audit rights if you don't actually go in and audit your third parties and audit the people who are doing this business. You will see if you end up in a regulator inquiry, they will want to know if you have audit rights, have you used them, how often have you used them. It's important when you're drafting your audit rights that you choose you think about who you're going to audit. Risk-based assessments always help, but this is also a really helpful place when you're deciding who it is you want to audit a way to tie it back to any due diligence red flags that you may have encountered back in the days when you were deciding who to bring on board. A lot of times you will find red flags in your due diligence process, and if you don't tie those red flags to actual mitigation steps, then you can have an issue. Audit rights and choosing whom to audit is a really great opportunity to tie those two together. Be clear who is going to audit. Is it going to be your internal audit team? Are you going to bring in external auditors? If you can specify that or get agreement on that in advance, we'll save you some trouble down the road. It is never a pleasant conversation to have with a business partner or third party to tell them you're going to exercise audit rights. Nobody likes somebody coming in and looking into their books, but it will help you if you can have an understanding at the outset of who is going to be conducting that audit. Timing and location of audits. It's very important that if you are conducting an audit pursuant to your audit rights, that you have it at the offices of the company that you're auditing. If you allow them to simply send in the documents to you, you will be missing a number of opportunities to get a real feel for what's actually happening. Access to documents. Again, this is something that's important to put in your audit rights because nobody likes it when they have to turn their documents over. Put in your contract what documents you expect to have access to in your audit clause. Is that all documents related to what that third party is doing for you? What does that look like? Also, you might want to consider, should you end up in the audit process, who's going to have access to the audit report? You may find that that's a particular issue if you're engaging a third-party auditor to conduct the audit, and if you don't think about that issue up front, you could find yourself in an uncomfortable situation. Finally, if you are exercising your audit rights, it's really important, if you're legal or compliance in particular, that you're engaging with your business while you're doing this. Your business still has to work with these third parties, and they need to know that the business relationship isn't going to be impeded by these audit rights because it is an uncomfortable situation, and it can be a bit, it just can make life a bit more difficult. Finally, because I know we're about out of time, there's a few other issues that you just might want to think about given what's happening in the enforcement world in bribery and infrastructure project. Charitable and political donations. We're seeing more and more that bribes are being used for both of these purposes, so you want to make sure that your due diligence process and your money trail is helping you understand where you're making these or where your money is going. Engaging with local stakeholders is really important because there are now increasingly a number of NGOs or third-party charitable organizations that can help you be able to track on the ground whether or not the construction activity in particular is taking place the way that you expect it to be. And finally, and this is also an important point to bear in mind, retaining your documents. If you've been through an enforcement inquiry relating to your business practices, you know this. But the problem with bribery and corruption is that your inquiry could come years later down the road from when you've actually been performing the services in the project. It might be years later that you get a government inquiry. It might be years later that you read about it in the newspapers. It's very important that you make sure you're maintaining your documents for all of these wonderful compliance steps and due diligence steps that you're taking. And also bear in mind in any M&A activity, if you're selling off a part of your business and they've been involved in projects in high-risk areas, think about what documents you might want to retain in the unlikely event that you start reading in the newspaper years from now that there's a problem. I know that's a lot of information that I've thrown at you, and we are out of time, but if you do have any questions, I would encourage you, if you want to stay on the line and put them on the chat facility, I'm happy to answer them. Also, feel free to reach out to me directly. But I appreciate your time, appreciate you taking the time out of your day, and look forward to answering any questions or helping out anything we can on any bribery concerns that you have in infrastructure projects. Thank you very much.